Welcome to the Business SOS podcast. This is Rich Sierra, president of the Florida Small Business Legal Center. This is episode 93 of Business SOS. We're very excited as we're getting closer to episode 100, perhaps in about a month from now. Today, we're going to be talking about a very important subject. We're talking about the rise of the Great Divorce, and I am thrilled to have my friend and colleague, Angela Neave, today as my guest. Let me tell you a little bit more about her. Angela is a dedicated family law attorney and founder of Neave Family Law, a boutique South Florida firm focused exclusively on family and matrimonial law. Angela is known for her courtroom strength, compassionate approach, and extensive experience helping clients navigate high-conflict divorces involving complex assets, including businesses. Angela, welcome to the show.
Rich, thank you so much for having me.
It's your third time you're here with us.
I know. I love coming here and working with you. This is so much fun.
You did episode 5 with me when I was getting started.
I know. It was like babies. Now we're all grown up, right?
Yes. And you did another episode that you interviewed me.
That's right.
As well. So very excited. I'm glad you're back.
Thank you.
So let's start about what is the Great Divorce?
So I love this topic, actually. The Great Divorce is typically divorcing families where the parties are 50 years or older. So we have special considerations that we think about when divorcing these families.
And why is it on the rise? I'm seeing articles coming out in various news media that they refer to the rise of the Great Divorce. Why is that?
A lot of reasons. I'll start with the fact that the Great Divorce is typically boomers. And boomers married young, and marrying young is one indicator of divorce, right? When you marry young, you maybe don't know who you are, you're growing up, and then you and your spouse grow up and realize you don't have anything in common anymore. So that's one factor. Another is the generational shifts. Women now are financially independent. And when back in 1970, they weren't necessarily financially independent and didn't have ways to become self-sufficient. Perhaps they didn't have a full-time career or couldn't obtain a bank loan or a credit card on their own. So now that women are financially independent and self-sufficient, they're no longer beholden to a marriage that maybe was less than satisfactory. So we have a shift in how women are able to live outside of a divorce. And then there's just the societal norms. Divorce now is no longer a taboo subject. People are divorcing with regularity. In fact, 50% of the population will go through a divorce in their lifetime.
Wow. I've actually been involved in from a business standpoint, representing businesses of people getting divorced in the 60s and 70s.
Yes, that's on the rise. Because when you think about our longevity right now, 50 years ago, people were dying in their 50s. Now people are dying in their 80s and 90s. And so part of the issue of the Great Divorce is once their children are out of college, perhaps out of the nest or even out of high school, they're looking at their spouse saying, do I want to spend another 30 years with you, another 40 years with this person? And if that answer is no, they're getting a divorce.
70 is a good time to get started again, I guess.
It is now. You could have another 20 years, which is a long time.
Yeah, that's true.
Yeah.
When we talked yesterday, there were other issues like health and fitness as well. Tell me a little more about that.
So there are a lot of reasons why people in their 50s, 60s, and 70s decide to divorce. And one of them is perhaps their activity level, right? If one spouse is less active and more sedentary, and the other spouse is more active and perhaps wants to play pickleball 3 times a week and go on hikes and do some paddleboarding, those spouses are not going to be very happy with the spouse that wants to sit around and watch television or maybe just has less energy. So that is oftentimes what is a cause for divorce. The people who are retired now are still not doing anything together. They're no longer in the workforce, separate all day, but they just have different ideas about what they want to do in retirement.
And that's a very important point. And also, I would imagine for travel as well. One partner wants to travel and the other partner physically not able to do it. Perhaps they're walking and, that goes to travel as well.
All of that. And travel is what a lot of us dream about when we're done working. We want to go see the world and enjoy the fruits of our labor. So that's really important. And I want to mention another thing when we talk about, health is sexual activity level. That's different for people as they age. And that is an important factor that spouses are looking at when they're considering whether or not they want to stay married. Are they satisfied in the bedroom? And is that something that's working for them? So that's another health consideration that the gray divorce parties are looking at.
As you mentioned that, I've been reading about this subject, hormonal shifts as well.
Yeah, it's challenging.
Which can be another podcast in itself with a medical professional. But
exactly. Yeah, but that does play a huge part because both men and women go through serious hormonal shifts, especially after 50, that dramatically affects not only their health and well-being, but also their sexual activity level. So that is something to consider, and definitely what our gray divorce parties are really looking at.
What surprised me the most is that people might not realize that they're making some really important decisions based perhaps on a hormonal imbalance.
That's true. And so as a good divorce attorney, I know a lot of my colleagues will sit down and talk about the emotional side of divorce and the impact that can have on a person who is seeking a divorce, perhaps in their 50s, 60s, or 70s, because while there is the health component and different lifestyles as you age, a divorce in your 60s can dramatically change your retirement.
In your life.
And your life.
Yes. So let's talk about that as well. And for example, in this case, what happens if both spouses own a business?
Well, that's a really good question. So the court is first going to look at when was that business opened, right? So the court is tasked with identifying the assets, classifying them. Is this a marital asset, a non-marital asset? Is it a non-marital asset with a marital component? Then valuing the asset and then distributing it, right? So if you're in Florida, it's an equitable distribution state in a divorce, which means the court doesn't have to split the asset in half. The business is not going to be cut in half and the parties are each going to take half. It doesn't work like that. Most businesses can't operate like that. What'll happen is the court's going to say, okay, the business is worth X dollars. I'm going to give that to one spouse and the other one gets the same amount of value in other assets. So that will happen. But if you own a business and are going through a divorce, a lot can happen, right? You're going to have forensic accountants and perhaps business valuators that are going to be looking at the books, determining what that business is worth, comparing it to other similar businesses, and it could have a substantial impact on the business during the divorce.
Yes. Just for the benefit of our listeners, just briefly, what is a marital versus non-marital asset? How does the court determine that?
That's a really great question, actually. So the bright line rule is any asset that was in existence at the time of marriage, at the date of marriage, is premarital. So if one of the spouses owned a business before the marriage, it is a non-marital asset. Now, they may have owned it for 6 months, and during their maybe 30-year marriage, they built up that business together. A majority of that business is going to be marital. The value is going to be marital, but it's classified as a non-marital asset. So the court is really going to look at the date of marriage and determine if an asset was in existence at that time, it's premarital. Anything that came into existence after the date of marriage is considered marital until you get to the date of filing. And that would be the date that one of the spouses files for a divorce. So if they open a business after the date of filing, that is also a non-marital asset, which can cause some complications because if one spouse decides to open a very similar business with an almost identical name right after the date of filing and then transfer all the business assets, it's a non-marital asset.
Yes. How can business owners protect themselves and their company? Say if they're considering to getting married, how can a business owner protect their company in regarding not having the issue of being split or being, considered a marital asset?
So we have some really effective tools. It's called a prenup. So I know I have talked about prenups before, actually many times. And the reality is parties can agree in a prenuptial agreement regarding an asset. So even if it's going to be both spouses are going to be working in the business, but one spouse owned the business or possibly inherited the business from a parent or a sibling, you can designate that business as a non-marital asset and state that it will not be valued, it will not be distributed. Any money by either spouse that's contributed to the business will be considered a gift to the owner spouse, and there will be no way for the court to distribute it. So a prenuptial agreement is a great way to protect the business. And if you are unable to get one or don't think of getting one prior to getting married, you can also get a postnuptial agreement, which is just like a prenup, except for it happens after the date of marriage. So those types of agreements are very effective in protecting the business in the event of a divorce.
Are these agreements that the parties can do themselves?
No. Well, they could.
I know the answer to that.
They could try. The problem is they're very specific issues, and it's different from state to state, but you want to make sure that that agreement is valid. And the best way to do that in Florida is to make sure that all of the financial documents and the financial explanation is attached to the prenup, right? The spouse that is waiving their interest perhaps in a business should do so knowingly. And so you don't want to just have a 2-page agreement or a 5-page agreement. You want something that really does talk about knowledge and a waiver of their interest in that asset. So I would say, no, you probably do want to hire a lawyer for a prenup or a postnup.
And I think it's also a good idea to both sides have separate attorneys.
Yes, it is actually a conflict of interest for one attorney to represent both parties. And that's, because if you're the attorney advocating for one party and they stand on opposite sides, right? You have one spouse that's trying to protect an asset and one spouse that might be trying to get their portion of an asset. So they each should have their own counsel. You don't always have to have attorneys, right? Florida is a state that tends to uphold prenuptial and postnuptial agreements. So you don't have to have an attorney, but it is recommended. And for the spouse attempting to protect their business or their assets, they should offer to at least pay for the attorney and allow their spouse or soon-to-be spouse to select an attorney if they're choosing so they can have adequate representation.
Yeah, and I think the consequence of not doing so is that, say, they enter into this prenuptial agreement, the business is successful, say 10 years in, they decide it's time, we're just going to get divorced. The husband gets out of the prenuptial agreement, the attorney's going to say he's going to challenge it.
Correct. Especially if it wasn't done correctly and didn't have the right attachments or the right disclosures or the right language, because it's not just the business itself. In Florida, we also value what's called goodwill of a business. And so there could be enterprise goodwill, which is just what does the value of the business have? What people just go in because they walk off the street and they know it's a good business, or personal goodwill, which is because of the owners or principals in the business, right? So I'll take my law firm as an example. Most people come in because I'm the owner of the law firm and I generate the business, but some people come in because I inherited the business from a former partner of mine, and that her business just had some additional enterprise goodwill that they just come in because they have the same phone number.
Okay.
So in my circumstance, it might be mixed, but you really want to have a prenuptial agreement that addresses that and that specifically waives any interest in the business.
But also who has more, I think, in a position of authority in a better position to negotiate. I think that's the word I'm looking for, that the agreement has to be fair for the other side. If somebody has more financial knowledge or somebody is in a better position of power to have this prenuptial agreement drafted on his or her terms, the other side is going to challenge and say, listen, this person didn't have consent. She was forced to sign this agreement. She had no choice.
Yes, those are all actually really great reasons why attorneys should be hired on both sides.
Correct.
Because in Florida, we uphold prenuptial agreements that are extremely one-sided, right? We believe here that adults should be able to make contracts, and if they're bad contracts, that's okay. You're going to be bound by your bad terms. But one of the things that a good attorney will do is explain to their client, okay, you want to protect your business, that makes sense, but let's provide for something for the other spouse. Let's say they are married to you for 25 years and they forego a career to help you, support you while you build your business, and that's the business that supports the family. If a divorce happens in 25 years, they don't have a career. They probably have been in the home the whole time, and they've waived their interest in the business. So a good attorney will advise one of the parties to, how are we going to take care of them? Are we creating a marital asset? Are we going to set aside an asset for them? Which tends to make it more fair and less challengeable, for lack of a better word. You want to make sure that it's fair so that when people go to divorce, maybe they're not litigating the validity of the prenup, which is an expensive endeavor.
In the first place, yes. Yes.
It can cost a lot of money to do that. And you do that first. So you would challenge the prenup first before you even get into the divorce stuff. So it's kind of like a bifurcated issue. And you can spend all of this money on the prenup and then still have the divorce to deal with afterwards.
You got to go through that twice.
Correct.
Much.
That's correct.
Wow. How does the Great Divorce affect retirement planning and division of retirement accounts?
Well, that's a really, really good question. And this is one of the reasons why I think great divorces require special circumstances. If we're talking about a 50-year-old, they probably still have 15 to 20 years in their business career to make up what they're going to lose in the divorce, because you're saving for retirement the entire time you're married, and you're going to give half of that away to your spouse. And if only one of you was working and only one of you was saving, and you have half what you thought you did. So if you're 50, you have 20 years possibly to make up some of that retirement savings. But if you're divorcing at 65 or 67 and you were thinking about retiring soon, or you're already retired, that money that you were living on now is going to be split in half. So that's one of the main considerations when when a couple is going through a divorce. You look at, where are they in their retirement cycle?
Yeah. There's a term called qualified domestic relations orders. What are those?
So a qualified domestic relations order is a court order that will divide what's called a qualified plan, which is typically a retirement plan, a 401k that is a company-sponsored 401k or a pension plan. So in a divorce, we know Florida is an equitable distribution state, which typically means it's half, but it doesn't have to be half of every asset. It could be more of one asset and less of another. But when we're talking about a retirement plan, half of the marital component is going to go to the other spouse, and you need that special qualified domestic relation order to effectuate that split, right? I can't just call up the plan and say, hey, give half to my client. I have to send them a court order that's been signed by a judge that says half of that money now goes to this other spouse.
And then they open a separate account, I presume.
Correct. What happens is they'll segregate the funds. So I'll make it up for purposes of our conversation. If it's $500,000 and one spouse is getting 250 of that, they segregate the 250,000 and hold it and wait for instructions, because it's either going to be rolled into a separate IRA that they have or that they're opening, and the money gets transferred, so it's not taxable, right? You're not having a taxable event at that time, which protects the parties, but segregates the funds so that the spouse who owns the actual retirement plan can't borrow from it or liquidate it. But those orders are very necessary to protect the receiving spouse's asset.
And this is something they should consult with an attorney.
Always. It's a good idea. And it should be done right around the time of the conclusion of the divorce. I have had clients come to me saying, oh, we didn't do this at the divorce, and I went to go have the qualified domestic relations order, which we call quadros, have the quadro entered, and the asset was gone. And so you can't go back and change things like equitable distribution. That's non-modifiable in Florida. So if the asset is gone, there's some remedies, but you don't have that asset anymore. So yes, definitely speak with your attorney if you're divorcing now, and make sure that they get that quadro signed by the judge and served on the company before they terminate their representation.
Wow. Is spousal support more likely or longer in duration in late in life divorces?
Is it more likely or longer in duration? So I see those as two separate things, and it depends on the marriage. So if this is a second or third marriage of the parties and they were only married for 5 years, spousal support could be likely, right, if one spouse didn't work, but it's only going to be for a short term, because in Florida, a short-term marriage is a marriage of less than 10 years. So 5 years qualifies, and they might have only a couple of years of alimony. But if this is a situation where the parties were married for 28, 29, or 30 years, then yes, there is going to be durational alimony that could be up to 75% of the length of the marriage or more. depending on if the spouse became disabled during the marriage or some can't work, again, cannot support themselves. So yes, it can be likely for a long period of time if the parties were married for a long period of time.
I have a question that just came to mind. How would this affect pensions and Social Security benefits?
Well, that's a great question. And those are
two questions.
Yeah, two questions and a lot of different things. So let me start with Social Security because that's very common. If the parties have been married for at least 10 years and we have one spouse that didn't work and one spouse that did, the spouse that didn't work can claim on the other spouse's benefit, right? So let's say you and I were married and you worked for 25 years and I didn't. And you go into pay status for Social Security and you're receiving, I'll make it up, $3,500. When you go into pay status, can take, and I take 50%. So I get $1,750. And I don't take from you. You still get your $3,500. I just get the benefit of $1,750, which may be more than what I've accumulated because if I didn't work for 25 years, I might only be entitled to $900. So that's one benefit that works for a spouse that didn't work, but that's Social Security. So that's built in to protect the spouse that didn't work, which is a great benefit because it doesn't affect the working spouse.
Okay.
Pensions are different. Pensions, you might require that quadro that we talked about. And pensions are typically split based upon the years of marriage, right? So what could happen is someone worked for 25 years during a marriage, but then worked an additional 10 years after the fact. That additional 10 years doesn't necessarily go to the former spouse. So then you look at the date of marriage and the date of filing of the divorce, and that value gets distributed equally between the parties. And once it goes into pay status, that quadro that's put into place will pay each of the spouses directly.
I know we talked about this in a prior episode. Once they file, it's very likely, actually, I think it's mandatory, they're going to go to mediation.
Yes.
And a lot of these terms can be negotiated.
Every single one of them.
Can you talk more about that?
Sure. So this is actually really good because in mediation, parties can actually agree to divide their assets in ways that maybe the court can't. And they can make their agreements with one another. So, for example, if we know the husband inherited a business from his father and he wants to keep operating that business because he plans on giving that to their sons, let's just say they're trying to hand down the business, then it makes sense for them to agree that husband keeps the business and perhaps the wife then receives more retirement money, or she keeps the marital residence, which might have substantial value, plus some of their cash assets. So you can make those agreements outside of the court. Once you get to court, you're kind of stuck with what the court can do, which is whatever evidence is presented to the court by the attorneys, right? The courts can't do something for which they don't have information.
Yeah. And that's also, I think, and I throughout my podcast, I talk about the benefits of mediation.
Oh.
And it's just, the way I look at it, when you go to the judge, and in this particular case, in family law, it's a judge, it's not a jury trial. It's one person will make the decision. You're saying we cannot work things among ourselves. We need you to make a decision for us. And the judge will make a decision, and you might not like that decision.
Correct.
In fact, most likely you won't.
Correct. And the benefit of mediation is even if you aren't thrilled with what your agreement is, people tend to follow the agreements that they make, right? Because at least they picked it and it's something they can live with. Once you go in front of a judge could rule against you, right? If we have a business and I'm asking to keep half of it, divorce judges don't do that because there is constant follow-up litigation after that divorce because they're still stuck as business partners and the litigation may remain in the family case. So a court could say to me, I'm sorry, I'm giving the business to him. You're going to get these other assets, which would be very upsetting for me. So you're taking a gamble when you go in front of a judge that the judge agrees with your argument, believes you, trusts your lawyer, believes the evidence is correct and will rule the way you want them to rule. So it's a big gamble to go in front of a judge. And basically mediation allows people to be much more creative. They're more apt to follow their agreements. You can do more creative things if you still have minor children. or assets that maybe you don't want to split. There might be benefits to keeping assets intact rather than splitting them in half.
You also have control and confidentiality as well,
Correct.
and closure.
That's all the
All three.
C's.
The C's, the 8 C's in my book. Which is, it's not my idea. Actually, a judge was talking about it in a federal case a few years ago, and I'm like, these are really good. So I just wrote them down and remember them, because they're, it really gives you the control and the closure and the confidentiality that are key. And when I tell my clients, you're in control of the mediation, I'm there to assist you.
Correct.
If this settles or not, it's because you made the decision, the other party made the decision, we write it up, but I'm here to assist you. I have no control of the mediation process.
Right. And if you do that before business valuators and forensic accountants start looking into the business, right? So what happens, I call it the financial colonoscopy. What happens when you have to value a business is that suddenly they're looking at the books and questioning your allocations and looking at cash and looking at why money is being retained in the business or why it's being distributed, or they're looking at everything and asking questions and then coming up with business valuations. So that takes a lot of time. It distracts your employees. It distracts the person themselves who's going through the divorce. I mean, one of the common issues in a divorce is that it is so distracting. It occupies 95% of their mental energy and awareness. So if they are supposed to run a business and be a CEO or a COO or do whatever they need to do to keep this business going and take it to the next level, a divorce is very distracting.
Yeah.
So going to mediation perhaps before all of that happens and resolving amicably is very smart for a business owner. And it will allow them to get back on task, which is running the business much more quickly than if you have to go through the whole judicial process and end it with a trial.
Yeah. On the average, how long does it take for a case that is contested from filing to trial?
It used to take, before COVID, we could talk about having a case closed in 6 to 9 months. Now there's no way that can happen. They are pending for at least a year or more, and possibly 2 years if you have businesses that need to be valued and you're working with everybody's schedules and you can't get on the judge's docket. So you're looking at 1 to 2 years. So 1 to 2 years of distraction out of your life. It's a long time.
It's a long time. But if they decide that they go to mediation and they find a settlement and they sign a settlement agreement, it could go faster.
Much quicker. You can do it expedited if you want to. You have much more control because you can perhaps use your accountant. And if you have an accounting firm that does the auditing, it's much easier for the attorneys and perhaps their own CPAs to look at the books because they're already audited. So there's a lot of things you can do that you have control over if you're going through the mediation process.
That's very important. In terms of estate planning and long-term impact, what is the impact in reference to estate planning in the Great Divorce?
Well, so you're really thinking about powers of attorney, living wills, healthcare surrogates, those advanced directives, things like that. So if you are considering a divorce and you don't trust your spouse to make those decisions, you want to change those documents. You're not required to, but you certainly could, and you should, right? If you're going through a divorce, what happens if you have an acute illness or are diagnosed with cancer or have something going on? You may not want your soon-to-be ex-spouse making those decisions for you. So you're going to want to name your sibling or your business partner or someone else that you trust, or if you have adult children, one of them, to make those decisions. So when you're talking about the Great Divorce and adult children, it's good to start designating those decision makers in your life at the onset of your divorce.
Unless you want to put the plug to be pulled faster.
Exactly.
Just
my
leave it the
husband
way
and
it
I,
is.
he jokes that he knows that I will have no problem pulling the plug. And of course I would. But yes, you want to have those considerations and discuss them with people, right?
It's very important. So what are the first steps should a business owner take if he's contemplating a divorce?
So you want to take a look at your business and think about what are the ways the divorce is going to affect my business. Is it going to interrupt my cash flow? Is it going to, take my time and attention away? Do I have capital assets that are going to be valued, sold, or split? Am I looking at selling my business versus keeping my business and continuing to run it? If I'm looking at selling, maybe I own a pizza parlor. If I'm going to sell it, what realistically can I sell it for? So if you're considering divorce as a business owner, the best thing you can do is sit and think first and think about what's going to happen. What do I want to have happen? And then those are the questions I'm asking the lawyers that I'm consulting with. And if it's, I want to keep this asset and I want to protect it, what's the best way to do it? And how do I want this process to go? So I think it sounds counterintuitive, but sitting and thinking and coming up with your plan first is probably the best thing. And then talking to a lawyer about what the options are.
I think two additional questions they can ask is, why do I want to get divorced? And what it's going to look like after the divorce.
That's correct, because we talked earlier about the emotional, and psychological ramifications of a divorce, a gray divorce, and then the financial ramifications. So for sure, you want to think about, what is my life going to be like after this? If I'm losing half of my assets, what is my life going to look at? And then consider, is it worth it? Right? Maybe you're just thinking about divorce, but maybe you don't really need a divorce. Maybe what you need to do is go to counseling with your spouse and see if you can either revive the marriage or learn how to grow together, or maybe it's just beyond repair. Or of course, if there's abuse going on in the household, that may not be repairable.
There's different circumstances, yes.
Correct. Yeah. But if there's not, it's definitely something that you should think about before you maybe even go speak to an attorney, or you have that conversation with an attorney.
Yeah. And I think that an advice also would be just to have a confidential consultation, which is confidential anyway, with an attorney before considering any type of filing.
Right. I have a lot of potential clients that will call and say, I'm thinking about a divorce. I want to understand what happens. And so I take them through the process. Here's how long it could take. Here's what we need to do, all the discovery we need to exchange. And then here's what your life could look like afterwards, after the assets and liabilities are split. And that helps them figure out, is this something I want to go forward with, or do I want to redirect my efforts back into making my marriage work?
And I think that consultation, just because they have a consultation, say, for example, with you or somebody in your firm, doesn't mean they have to file.
That's correct.
Simply getting information about what are their options, because it's a very important decision.
Correct. And I love having consultations with people who tell me that, because that tells me they're thoughtful, they're smart business owners. They want to make sure that they're making the right decision for themselves, their family, and their business. And they're going to be, overall, they're going to be happier with the resolution, because they've been able to think it through, not only emotionally and psychologically, but also financially.
It is, they decide not to go through with it, that is fine. Nobody's going to judge them.
Correct.
Nobody's obligated to pursue it, because really it's going to change their lives, especially somebody in their 60s, 70s. It's going to change their life forever.
Correct. And I got to say, when people come in and consult with me and they decide that perhaps the divorce isn't worth it, they may ask me for a referral to a marriage therapist or a marriage counselor or individual counselor. So I make a lot of those referrals, because sometimes that's just what they need, a little help. And it's not divorce.
Yeah. And, it's a very difficult subject people just don't want to talk about.
Correct.
But I'm glad we're talking about it today. We have quite a number of listeners, and I think, as people get stressed, sometimes you'll make decisions. So at the very least, this provides some guidance that they're considering pursuing divorce at some point in the future. Angela, how can people find you?
Well, they can go to my website, nevefamilylaw.com. They can call my office at 954-981-2200. Those are the two best ways. So call me up or go to my website. There's a way to fill out a form and get access to me, or just call me up. I'm happy to talk to anybody. I love to discuss a potential divorce, just give you information. It's very necessary and much needed.
Yes. Your office is located in Fort Lauderdale, correct?
I am in Fort Lauderdale.
In where do you take cases in terms of which counties?
So I'm in Palm Beach County, Broward County, and Miami-Dade County.
Okay. Angela, thank you very much for coming again today to our show. I'm very excited. Obviously, I'll have you next time. Maybe you interview me this next time. You're like a surrogate host now. Or
I would love to. Thank you for having me today.
I love to have your expertise, and I certainly appreciate your friendship as well.
Thank you.
Okay. Let me close the show the way I close it. Again, if you want to reach me, my email is rich@richsierra.com. If you want to learn more about the legal services that we offer, my website is floridasmallbusinesslegalcenter.com. Remember, my book, Business SOS, 8 Common Legal Mistakes Business Owners Make and How to Avoid Them. It's available on Amazon, Barnes & Noble. You can ask for your local bookstores as well. If you want to watch the video of this show, we're on youtube.com/@RichardSierra. Remember to give us a review, follow us, and share it with your friends as well. Until next week, this is Rich Sierra. Remember that my goal is to help you succeed.